Hey there. As you can imagine, we've gone up and down the omnibus, tried to kind of like do our research on that and dig into it. There will be a nice report next week, and we'll publish all the details in proper writing. However, we also realize people like to just listen to stuff and not just read it all. So we put together this nice little video here trying to kind of go through this omnibus and what that all means. I think we'd start out with a bit of a background where, especially for lawyers that are not too familiar with how Brussels works, where did a lot of that come from? We usually have the head of the commission, obviously, from the line. Then below her, there is Virkunen, who is in charge of DG Connect, so to say, which are the people that are usually in charge of communication, content and technology, so basically promoting digital Europe, so to say. And then there is Michael McGrath, who is the Irish commissioner that is in charge of justice and rule of law and democracy, and that usually deals with GDPR, that unit here. So there is this DG Just element that usually does all of these things. Now, for the omnibus, the pen was kind of in the hand of DG Connect. And traditionally, the rumor in Brussels is that they always wanted to lower the GDPR a little bit because it's in the way of their digital agenda. But also in reality, we saw that DG Just was kind of going a bit the direction of rather lowering the standards. So you oftentimes see at Court of Justice rulings that DG Just is the one that was oftentimes arguing against the more privacy side at the Court of Justice. So it's interesting that you see a bit of this tendency in the different units. Now, officially, this change in the omnibus was only meant to kind of deal with the cookie laws and cybersecurity-related matters. That is stuff that was originally meant to be in here. Now, we did have a consultation, a call for evidence at the beginning. More than 500 people have put input in there. I would assume it's probably more than 5,000 pages or so. If everybody put around 10 pages in, you're quickly at numbers that are extreme. Now, quickly thereafter, we actually then heard in the commission that there were drafts and the first calls, and that was partly just 13 working days after the official consultation. So let's be honest, no one probably went through the whole consultation papers that came in here. Let's assume most of that stuff was somehow coming out of the European Commission somehow else. There was then within the commission, and there are different services, partly even just 5 days to working days to actually review all of that. So all of that is very fast paced and very quickly done. We then had another 5 days to fix stuff. That was around the time when all of that started leaking, the end of the review phase. So they did have some time to fix some of the problems that were in the leaked documents, and they actually really did. But we're now at this final stage where basically the documents are public. That was now released on November 19th. Moving forward, this all has to go through the European Parliament and the Council. They say they want to have a fast-track procedure there, but that means that probably there's less time to do amendments, less time to actually scrutinize the law, which is quite problematic. But we don't know if these other institutions are actually going to do that. So it could be that the other institutions say, frankly, this is more than a tiny little change that you've promised to us, so we'll actually take a bit more time. So we'll see how the fast track goes, and when the next step happens, there is no timeline for that yet. Now, at the end point, we would somehow have then the final law, and would actually then know if all of these changes actually become reality or not. So far, all of that is just a proposal by the European Commission, and these proposals can get changed. One major element that we're a bit concerned with is usually at the European Commission or at European lawmaking, we have certain quality elements. There is typical these better regulation rules to do impact assessments, to actually look at the law properly. And in this case, most of that was unfortunately not done. And to be frank, you then also see the consequences if you look at this law. What's important, the Omnibus has a lot of elements that are changed. We were just concerned with GDPR and ePrivacy, but there's a lot of other laws that also partly got changed by this Omnibus. And what was the input? How did we get here politically? I think it's always important to remember that when the GDPR was passed, as much as it's talked down to by industry lawyers and by lobby groups, the GDPR was passed with a massive majority. That is the green part here. The red part is the people that voted against the GDPR when it was in the European Parliament. So this law has quite strong political backing. There was a so-called stakeholder event. We were also there where basically the stakeholders were around and could say something on problems. And what was interesting is that most of the people there said, we don't want a reopening of the GDPR. I had the feeling that when everybody left the room, also the industry side was like, God grace, we are not doing a recast of the GDPR. But there was apparently quite a lot of political pressure to do it anyways. The narrative was very much like the GDPR is killing us all, the world goes under. I think one important thing is that in reality, this is quite the opposite of the numbers that we have. Like if we look, for example, at enforcement of the European on the European level, we have on average, this is the countries where we basically looked at how many fines do we have per complaint, which is a bit of a weird metric, but we try to at least make it somehow measurable. And we right now have 1.3% of all complaints that ever see a fine if you assume that every fine has ever been based on a complaint, which is not true. So the reality is we have very, very little enforcement. And this fear of, everybody's constantly having fines going after them, in our experience, is pretty much the opposite. So also at professional conferences that I attend a lot, there's more and more talk about that most companies probably wouldn't even follow the GDPR anymore. And also professionals, therefore, their services are not needed that much anymore because the feeling is there's not much consequence. We also asked for a while ago data protection officers of how likely it is that you're going to find major violations in an average company, and more than 70%, I think 74%, said that if a DPA would walk into a company tomorrow, there would be relevant violations. So I think the idea of this all being a bit too much is in reality more the opposite of a lot of that not being enforced that much. And it's interesting that this narrative is very different. But if we looked at the feedback, the stakeholder groups were largely like no reopening, at best targeted changes, a little discussion about definitions. There was hardly any of that. There was wish around clarifying AI, that's for sure. But otherwise, we didn't really see that big push. Nevertheless, we can also look at what the member states ask. There is a document where the different member states that did respond largely also said, please, no changes. There are documents that are public where Germany and Denmark has pushed for changes. So also here, there's a bit of a mixed bag of pictures. What we now had reporting about is that there was certain like background talks that the Commission had with industry lobbyists that may have inspired a lot of these changes. Because in the other discussion was not there that much, at least in our perception. Now, what's important that we go throughout this video is that we oftentimes mention the Charter as well, because after all, Article 8 of the Charter has the data protection rights that we have. A lot of what is in the GDPR is directly taken out of the Charter. So, for example, purpose limitation is in the Charter. Consent is in the Charter. The access rights are in the Charter, and so on. So if we change anything that touches on these rights, you usually have to do a proper assessment. And what's important is if we interpret the GDPR, we usually have to do that in light of the Charter. So a lot of the GDPR 99 articles are more or less implementing the Charter as it is. When we look at the Omnibus, there is usually a part where the European Commission has to explain how this all goes together with fundamental rights. What is interesting is the only fundamental right that they explicitly mentioned that they have tested it against was actually the right to conduct a business, which, spoiler, is not a right as it's generally announced oftentimes in the privacy bubble. It's actually a freedom. Which is less than a fundamental right. And the other thing is that it's very limited. The right to conduct a business means that you can open a business, that licensing must be somehow reasonable to open a business, stuff like that. But it does not mean you can just ignore the law. Explicitly, the right to conduct a business explicitly says only within the realm of the law. Otherwise, you could also say, I don't pay taxes, and anything else that is bad for business would violate these rights, which is not what this right does. Even though many people just throw out the right to conduct a business randomly to kind of have a counter fundamental right, but it is actually a very limited right, and it's important to stress that. Now, they also then said that later on for privacy rights, that all of this is actually just improving privacy, therefore there doesn't need to be any impact assessment. That is quite extreme. Like if we look at the changes, this is a position where basically the only right that is seriously concerned here is the right to conduct a business, is quite a telling way of dealing with this problem, and probably speaks a lot on the rest of the changes where all of this is coming from. Now, what was also interesting, Paul Nimitz, actually, who was the lead negotiator for the GDPR originally on the Commission side, now retired, actually posted even on LinkedIn that he thinks all of that is a violation of the Charter, or probably not all of that, but a large part of it. So it's quite interesting that even people that originally on the Commission side have negotiated that may not actually be compliant, be in agreement with all of that. Now, after this little intro, we now go through the different parts. At the NOYB office, different people of our team have actually looked into elements of the law. What's important is we have not looked into all of that and didn't want to have this video be like 5 hours. So we focused on the problematic part. I want to stress at the beginning that there are parts that we actually welcome quite a lot. And I think that are also common ground and largely are the things that originally we thought this omnibus is going to carry, where there was public discussion about, where there is also benefits. To give you a good idea, white and black lists on data protection impact assessment definitely makes sense. Having a centralized place where you can report security incidents definitely makes sense. No problem with that. I think that is important that we didn't have all of them in just to say this is great. We just now focused on the problems that we have because we need to address them. Also, to a large extent from practicality perspective. So privacy professionals we talked to the last week were oftentimes outraged saying that actually this doesn't help business either because it's so complicated. And it will at best help big law firms. It will at best help big tech companies because they can use that as little loopholes. While for the normal controller that probably is just annoyed with tons of, admin work with a lot of documentation duties, there's very little in this omnibus for that part of the industry, which originally was the argument of the commission to say we help European business, we help basically the small guy here. To be frank, we don't see that anywhere here. But make up your own mind. We'll try to kind of go through these individual parts in the next sections with one of the colleagues that have worked on that and also publish more of that in writing the next days. Let's move on. So on the first detail here, the personal data definition, Leban actually looked at that a lot for us the last weeks and days especially. What do we see here? Let's probably look at our presentation. There is, first of all, the definition question. How does the definition now look like?
Well, the definition right now still keeps the identified or identifiable part in it. However, the issue that actually pops up in this case with the change is that it becomes a subjective definition of who is identifiable and who is not identifiable, which users. And on top of that, it is the new description also mentions the likeliness of identification, which you can argue is a double subjective approach, and it's very much context-based. And also, one other issue that the new definition has spurred is the fact that further use is not accounted for as much anymore because an individual entity can process as much data as they like, deem it pseudonymized enough for individuals not to be identifiable, and that is independent of whether another entity can actually re-identify those individuals or not. So some companies, in this case, would get a free pass to process whatever data they want because it's pseudonymized to an extent that it's not identifiable.
And what's interesting, the argument was to kind of simplify stuff and so on. And subjective definitions are by definition not simple because you have to, like in each case, have like it's personal data for one and not for the next. And then for the third one, it is again. So that would probably defeat the simplification purpose to a certain extent. And what I was thinking was interesting is also kind of the current approach under the GDPR that we have. So we looked a little bit at recital 26. Maybe you can explain a little bit the differences we found there.
Yes, definitely. Currently, what in the recital, what we have is about the definition is very much based on singling individuals out. So it's not necessarily based on an individual's name, email, user handle, or something like
So that's actually for pseudonyms. With the pseudonym, you can usually single a person out, and you would be in the current definition.
Exactly.
Yeah.
Exactly. It is irrelevant to the pseudonym if you have their name or not. The companies can still process the data on an individual level because they single an individual out. However, the name is not there, so thus it's pseudonymized.
Yeah. Then basically what's interesting I found even with the SRB judgment that we now talk a lot about is at least the recital so far says identifier identifiable by controller or another person. So that would basically have this objective approach because if any other person can identify it, you fall under the GDPR. And then basically it seems the Court of Justice already ignored that part of the recital and we're now trying to concrete the ignorance of that recital in. The recital is not legally binding, so they can't just say that's not it. But that's kind of one of the biggest differences, I would say then.
Definitely, especially if we look at the new definition, the independent of further use or not. If it's not dependent on that, then yeah, the recital is completely, this part of the recital is completely tossed out the window.
So we have, and also the reasonable likeliness now becomes subjective, and especially on the further relevant use, there was one or two cases that already said exactly the opposite of the new definition, right?
Yeah, actually, we've been hearing a lot of talk about the Scania case, but from our interpretation, we understand that the Court of Justice actually mentioned that VINs, although might not be directly might not be personal data to an extent that the manufacturer might identify.
A VIN is a vehicle identification number. So each car gets a number, and then you can, in the background, link the owner of the car to the car, and thereby stuff from the car becomes quite personal because you know where the car is, and if it's like in front of some place that may not be, that may be a sensitive location, for example.
But the issue that we have, exactly, first of all, thank you for the definition. However, the issue that we have right now is exactly that it is just a random string of numbers, although unique to the car. It is a random string of numbers, and hypothetically, someone can argue that it's just a random string of numbers, it's not really attached to anyone, but that's exactly what the court said.
Yeah.
The court says that otherwise, just because the manufacturers themselves cannot attach it to an individual, does not mean that other entities down the line cannot. And given the fact that they can, that means that the VINs produced by the manufacturers also should indirectly count as personal data. So a broad view on what personal data is, even if it's pseudonymized.
So we're actually not clarifying the law here. We're changing the Court of Justice rulings at a large extent, I would probably say. What I found interesting as well is the quality of the text. I mean, even if as a company you want to rely on that, a lot of the wording is, it may not necessarily be personal data, or not merely because another entity, which is like, not merely because, does that mean never, sometimes, ever?
Yeah, I don't know. Sounds kind of vague to me.
Yeah. I mean, in practice, that's going to be quite interesting because, I mean, if you, for example, dodge the whole GDPR saying, oh, I fall outside of it, and then some DPA says actually that merely because only means, it doesn't always mean, but in your case it meant, then you may have to 20 million euro as a fine as a consequence if you made that analysis the wrong way. I mean, there's more wording like reasonably likely to be used by that entity. So, I mean, for example, a data protection authority would have to figure out if a company is reasonably likely to do something. So they have to look into the brains and minds of the managers of a company to figure out if it's personal data or not, which is quite interesting. Also, basically, with the merely because a potential subsequent recipient could basically figure out would also not qualify. So a lot of these definitions, I was wondering I mean, you were in privacy practice on the other side before or joining us, working for a company, what are you going to do with this?
Yeah, well, we directly go back to the Scania issue as well, that just because someone else can identify it, now the GDPR is supposed to say that just because someone else can identify it does not mean that it's personal data. However, there are instances where two companies transfer data to each other, and one company might be a processor, the other might be a controller. And besides that, one big issue that I see is, yes, there could be a potential case somewhere out there that, yes, currently the data that the company holds, even in pseudonymized manner, cannot be traceable. Yes. However, technology advances, things change, companies get bought and sold, and the data that they have amassed and the deductions that they have done via the processing of that data might not be personal right now, but soon in the future it might become such. What do we do then?
For example, for reasonably likely, is it reasonably likely now or in a year or in 2 years? Anyways, we're not going to figure it out, but the commission will probably argue that they are going to be able to do an implementing act to basically define all of that in a wonderful way. And then all these uncertainties that we have in the law may just be clarified because the commission tells us so. Now, my first reaction to all of this was, the commission is not going to come up with like an implementing act naming 5 technologies that are wonderful pseudonymization. The reality is going to be, there's going to be tons of push from lobbies to say, I have this thing, there is hashing, please put this in the law. And I mean, this can also change over the years. I mean, we saw currently and also before that the commission has a strong tendency to just give up gradually. It's going to be very hard to get any of these definitions back out politically.
And codes of conduct?
Not really, but different story. But what happens basically once the commission comes out with an implementing act? You looked into that a bit more as well.
Yes, well, once the commission comes out with an implementing act, it of course gets sent to the council. Council of the European Union, and after that it should get passed, if it of course gets passed, and then it should become law. And what happens then?
Yeah, so basically we were thinking through that. It was like, now we have an implementing act. I mean, the most famous implementing acts in the GDPR, I think, are data transfers. Usually that was also an implementing act by the European Commission. And the only way that you can get rid of this in reality, unless the Commission actually turns around, which politically in reality is hardly going to happen, is that the Court of Justice would come around and say, actually, this definition goes too far, because personal data, and we'll get to that, is a bit defined in the charter itself, really. And they could then cancel it out. And if that happens in reality, we may, that's my prediction politically, have 10 or 15 years just with the data transfers of the Commission being pushed to do another implementing act by the industry, as we have it with data transfers. Then the Court of Justice saying, no, that was a bit much here, moving it back again. And interestingly, if the Court of Justice overturns something, that's ex tunc, so it retroactively says that this was never legal, which would mean companies relying on it illegally relied on something, and you could, for example, have questions around damages and so on coming.
And then what do we do with the data that has already been processed?
Yeah. So the other question I had, and to also kind of move forward a bit, the question in real life consequences. Because first of all, I was at a business conference a week ago, and they were like, oh, subjective definition sounds nice for us. And then we started the debate, and it was like, how about if it comes to controller B? And you usually work together with other companies. And I don't even want to open up the processor question on all of this. But basically, if controller B usually is, for example, protected by Article 32, because they cannot just share the data and give it to someone else. So we can reasonably exchange data with other companies. If they now fall outside of the definition because they only get pseudonymized data, what would be the consequence, I assume?
Well, the consequence would be that they get a free pass to basically process the data, and they also get a free pass to potentially transfer it on to other companies as well. And the bottom line is that they would not be covered by the GDPR anymore. Their actions would not be covered by the GDPR.
And though 32 is gone, and I mean, what we then said is basically you can leak that data thereafter publicly, because basically 32 is the only thing that keeps you from, just using it if you don't fall under GDPR. What is even more interesting is it's to a certain extent circular, in the sense that only because you separate the data properly, it is pseudonymized.
Yeah.
But then the laws that require you to properly separate it are not applicable to you anymore. So it's a bit like, a cat biting its own tail. But that was the first thing. The second thing that came up in these discussions was kind of, what about joint controllerships, for example?
Yeah, this is very interesting because, for example, even if we look at the Fashion ID case, in the case, the fact of the matter was that for one company, they were gathering data at the same time. And for one company, data was actually relevant and usable. And for the other company, the data was more or less useless and, in this case, pseudonymized. However, since they were gathering it together, they were joint controllers. What will happen now? When for one company it is impossible to actually get any use of this data and process it, and for the other company not.
The second one would be pseudonymous data would fall out of the definition of a controller. So if you're not a controller, you can hardly be a joint controller. And yeah, so how that would ever work in practice and how a lot of these contracts and contractual arrangements we do is probably unclear. Yeah. I was then also a bit intrigued about like the data transfer discussion. Obviously, it's like if we have another company that acts as a data exporter and they then don't fall under Chapter 5 anymore because they have only, let's say, good enough pseudonymized data. Not all pseudonymous data falls under this new definition, but they're going to make that argument, and then you can just ship that data to a data importer somewhere else that may have the keys or may be able to re-identify that it's in China or somewhere else, and you wouldn't have any level of protection on the way.
Where the GDPR is not applicable.
Yeah. And yeah, I mean, the geographic, in addition to what we see here, there's tons of questions about geographic applicability as well, because a lot of that does in practice not mean that even if they fall under the definition of personal data, they may not act on the European market. They may just de facto ignore the GDPR because they're somewhere else on some island. So that's also going to be interesting if you don't have a chain of companies that all fall under the GDPR, but parts of the chain do and parts do not, then a lot of the protections we have may get a bit leaky.
I would say the Chapter 5 was the entire deal of protections here, but it might not be applicable anymore.
To wrap it up, a couple of real-life consequences that we saw there is basically anything where there's a mere identification sufficient. So basically, if companies don't really need to know the name and it's enough to just have the ID of the person, that could be all situations where suddenly the GDPR would not apply that well anymore. There could be even situations that we see where you split identification and the core service. So we have more and more of these cases where companies don't really identify people anymore. They just do log in with Facebook and then get from Facebook just a string, just a random identifier. And that could potentially allow you to kind of escape the GDPR largely.
Definitely, and it's more comfortable for companies to do that as well because there could be multiple MUX hypothetically, but if they assign you a unique ID, they don't even need your name anymore.
Yeah. A couple of other examples that we thought about is that this could be massive loopholes, like basically you just split your company or processing in 2 or 3 and then you can escape the GDPR. There is the big question of online tracking. I mean, almost all online tracking is done with random strings where they're not really knowing who you are. Again, that is the most extreme interpretation of this new wording, I have to say. So some people say that's probably not meant, but a lot of the companies that are in these spaces are definitely going to try and say, this is what we understand here now, and may probably use that. So stuff like Fashion ID that we heard before,
Exactly.
IB Europe would probably be retrialed or at least discussed. I was even thinking CCTV could fall outside of that definition, because if I'm a, I don't know, supermarket and I have like thousands of people run through every day, am I really able to re-identify them in practice? Probably.
The means?
Do I have the means? Do I have the intention to do so? For most of them, probably not. So it would be interesting that even situations like that, they could start arguing, oh, the GDPR doesn't cover us. So a couple of like real life cases we have, for example, the statistics of Xandr, which is the advertisement arm of Microsoft. And they, for example, never gave access to any of the online tracking because they basically made the argument that this is all ID numbers and therefore you don't really have to give access because it's all pseudonymous enough to not fall under GDPR. So that's already happened the last year. So it's not really something that is new, and that could be kind of pushed for by a lot of these companies once these new definitions are out. But we even have these discussions in like totally normal online tracking cases. So one of the big newspapers in Austria said, all the online tracking actually doesn't fall under GDPR because actually we don't know who is tracked. And that's basically the advertisement partners of us that do all of that. So we're out of the GDPR. We don't even have to do any of this, which was a bit weird because, I mean, they do have a consent banner. So the argument was a bit interesting, but nevertheless, they make these arguments.
And in your opinion, does it matter to the average data subject if the controller has or data processor has their name or not? Or does it more so matter that they get direct advertising, which they did not?
Yeah, and I think the Court of Justice in some of the rulings really said, it's about also the consequence for a person. If there is an individualized consequence from the processing, we fall under that usual understanding of this is covered by the GDPR. In reality, we have to really look at people probably don't care if they're identified by an ID number or by something else. And almost any computer system in the world works with a pseudonymous identifier as the primary source. You then just add the name to that pseudonymous data. So the idea, I think, of a lot of the lawyers is that pseudonymous is something like magical, not understanding that 99% of most systems run on pseudonymous ID numbers. And even we have that in the courts sometimes that like judges are like, yeah, but it's a random number. I was like, yeah, your license plate is a random number too, but it codes for you. So it's quite interesting because these arguments would probably get a lot of wind there. Couple of real life consequences that we also think is crucial is that basically the proof for a data subject, all of that is thought from the position of the controller that may know or may not know that it does that, these subjective definitions. But we have two other players usually in a lot of cases. So we have the data subjects, and they usually wouldn't even get the Article 13, 14 rights, so no transparency, which makes it really hard to figure out if there is any kind of pseudonymous data or not, or for example, no information who the controller even is, no information about the recipients of that data. So even if we say there's a chain and the second person may be able to re-identify you, you never find out that that second person exists because 13 and 14 is gone and the recipient information therefore is gone. What's also interesting, if you doubt that it's really pseudonymous and you're like, hey, I want to make an access request, the companies are probably going to come around and say, it's not personal data. We decided it's not, so therefore you don't have an access right and you can't even prove it's actually not pseudonymous enough. Let's put it that way. So it's a bit of a chicken and egg discussion, really, if you think about it, that it gives enormous leeway to the company because they say, oh, in my subjective intention, I'm not doing it. Now you have to prove my mind to be wrong.
Yeah. And that it could definitely be the case as well that these companies check the boxes that the European Commission puts forward with the Implementation Act, and their self-assessment is already done, and effectively, legally even speaking, they're not covered by the GDPR anymore.
The other big question we also then had is what happens to the data protection authorities? Because, I mean, we already know that they're pretty, let's say, overworked and kind of do a lot of extra time already. And we thought it's going to be interesting that for a lot of these cases, supervisory authorities for each case would also have to figure out again and again, do you actually fall under the GDPR? Is that actually covered? So you probably have a lot of situation where the GDPR cases will need some kind of like a pre-case to even figure out, does the GDPR now apply or not in this situation? And to give an example, we had sometimes in Article 15 access request discussions where just investigation took 5 years to get access to the data as a first step. And then you would probably appeal that. Then at some point you actually get access, and then 10 years later you can actually exercise your data subject rights. And a lot of these delays usually come from discussions around, is that really personal data? Does that even fall under it? Does it not? So there is a lot of potential delay for that. The very last one that I wanted to kind of cover is, does that all comply with the charter? We had some doubts, I think, there, right?
No, I don't think so, because the definition of personal data in the charter is also taken from the Data Protection Directive from the year 95. And in that directive, the definition is quite similar to the GDPR currently. However, it would effectively make it the case that in the directive, the definition of personal data is actually more broad than in the GDPR. So it could be the case where we have a clash between the GDPR and the charter, where charter affords more rights to individuals, and since the definition of personal data is more broad, and then the GDPR affords less rights.
Yeah. So you would run into an annulment of the GDPR personal data definition in reality. Because, I mean, the Court of Justice is probably going to look at that and was like, that's not what we meant. And then we may find out years later that this new definition is to be annulled because it doesn't comply with the charter definition, so to say, of personal data.
Definitely.
Yeah. So that's going to be very interesting. Let's see what politicians do around that. So next up, we're talking about research exemptions, which is kind of new to the GDPR. You then found it in the later version. It was not in the leaked version, but now we suddenly have a research exemption.
It's a little bit of a dark horse.
Perfect. So your team is going to write us on this dark horse, and we'll go a little bit through these articles and what the exemptions really are.
Yeah. That's what we're doing. So the definition of research, well, we start with basically scientific research is any research that can support innovation, such as.
So such as is even open list,
Yeah,
not even closed study.
This is just examples. Technological development and demonstration. So like technological development being basically product development, I would have to assume. So in-house, this is written, but like specifically for SMEs, they say that we want to innovate. Like that's the point. So make it as broad as possible so anyone can do research.
And they're a bit like a limitation-ish part of the second part of that definition.
Yeah, you could argue that it's about limitations, but as you see here, like these actions, as in the research, shall contribute to existing scientific knowledge or apply existing knowledge in novel ways. So you don't even have to actually do research.
You should apply research in novel ways.
Yeah. Okay. So what you need to do is you need to do something new.
Okay.
Whether you're actually doing research or just doing something new, like you're applying. It doesn't matter. Like that qualifies. And so here you see that another limitation is that it needs to be carried out with the aim of contributing to the growth of society's general knowledge and well-being. And my problem here is that, well, I don't actually know what society entails, and I don't know exactly what well-being entails. I assume that you and I and every company that exists in our society is part of society, and that economic growth is part of our
well-being. Yeah, so it's pretty broad on that side.
Yeah, and it doesn't have to actually contribute to this. It just needs to have that kind of
able of contributing. Okay, it may fail in contributing to society and still basically fall under.
you don't gain any knowledge.
And you could also but they do say that you have to adhere to ethical standards. We're gonna get to that and then into slide.
Yeah, and this sounds great.
And then there's a last bit which also is part of this limitation, but not really.
So this is another thing that where they say that it can also be part of a commercial interest, and that kind of ties into this thing with the innovation aspect and the goal of this whole new definition and purpose of the Omnibus, I guess, that we want to innovate and therefore we shouldn't stand in the way of commercial interest. And they're very clear that this is the purpose.
Yeah. So we generally have a super broad definition of this like research that goes beyond what traditionally we would understand as research. Yeah, that's kind of the bottom line.
Normally I would say that for something to be qualified as scientific research, you need to apply the scientific method and you actually have to do some kind of research.
Yeah.
No more.
Okay.
Yeah.
And now how does that link basically to the rest of the GDPR? Because we now have this new definition, fair enough. But where does it link to?
Well, the first thing is the purpose limitation that already states that if your purpose is to do research, that is, not incompatible with the collection purpose. And here with the broadening of the definition and the clarification of the purpose limitation principle that they've added, anything you do that furthers your own knowledge because you're part of society can
overcome purpose limitation.
Overcome the purpose limitation principle. So it's just like I don't know where to draw the line here. Like it's just so broad, and I think this is the broadest like expansion of the GDPR in this. Yeah, like the second part here, as you see, is about the transparency, where essentially the Commission suggests that if it's too hard or if it hampers your research purpose, then you don't actually have to tell people whose data you have collected that you're going to be doing research, whatever research actually means to you.
And then there's this national opening clause we ever had, and I have ever since in the GDPR, and that was a bit my issue that I had. I was like a bit, usually we have basically national law that further allows research already.
Yeah.
With this broader definition, this national opening clause is enlarged. And being the little Austrian here, I mean, we have in Austria a research law that basically allows almost anything to be research, so to say. So it's quite interesting that there we actually have that situation that a lot of the research is then automatically legal. I mean, obviously in Austria, for example, that definition is probably against the charter and against the GDPR as we have it right now. But for 10 years, no one litigated that. So it's the standing law and people can just use that for now. Couple of examples of this, like to make it a bit more plastic. Research examples we found so far already.
Yeah, like research example, like the Royal Library of Sweden already claims, for example, that we're doing research when really what they're doing is just they're training AI models on everything that's been written in Sweden. Their entire library is just being used to train OpenAI and other current models in Swedish. And I mean, you have this idea that like we want to further our own knowledge about our user base, so let's track people online using cookies, for example.
Yeah, that's the market research is
market
research and
research. Yeah, it's beneficial to society because it makes you have a high revenue potentially. And I mean, same with the customer research. Like I want to know what people buy and who buys what, and that is beneficial to...
So basically the shopping cart where you research what your people are interested in.
Yeah, that can...
I mean, a case that I came up to my mind a couple of years ago, Meta basically used all the Facebook data to figure out if a relationship stays happy or not. And they were actually able to predict that. And it was interesting. That could also then be research, so to say. The last bit that we wanted to talk about as well was kind of this question of ethical standards. I mean, the definition says you have to follow ethical standards in your domain, but what would that mean in reality?
Well, in reality, the problem is that I don't see that there's a lot of research domains that, when we're talking about research on personal data specifically, that have ethical standards in place. Usually this is either done by national legislator, national ombudsman, or national authority, or we have general standards. So here we're saying that, oh, well, we should have specific standards for specific research fields or industries. And the risk is that the industries or research fields determine their own standards.
So a lot of the standards in reality are written by that industry sector and not by the general public.
That's what we can imagine. I mean, I'm sure that OpenAI has certain standards when it comes to AI research, for example, since they are, the groundbreaking research people on that field.
What I also found interesting, is that to a certain extent, if the law just refers to standards of that industry, is that we're kind of outsourcing the right or wrong question from the legislative process and move it into whatever the industry domain has decided is the standard is now legal or not.
If we say that the standard is the minimum compliance tool to follow the law, then we're basically also saying that companies that do research self-govern.
Yeah.
Which is
with that broad definition of problem, getting us to the last question that we have in each section, charter compliance, because basically we're now exempting purpose limitation, which is in the charter, processing allowance, which is in the charter, and so on for that whole sector.
Yeah, I mean, it's charter compliance. I think that the proportionality aspects and just the fact that we devalue what research purpose actually is a problem. I mean, yeah, we say that research should be free in the union, but there's limits to freedom.
And there's limits to probably the definition of research. So it could be that certain cases there are stretching it too far, and then probably the Court of Justice would have to say, guys, this is a bit too much for a general exemption from the GDPR.
This whole thing doesn't feel very well thought through.
So next one up is Cleanti, who actually looked at all the AI stuff and that is in this new change. So I usually, when we talk about the AI discussion, I usually kind of allude that originally when we came up with all these principles in the 80s at the Council of Europe, the idea was always that we're going to have this big algorithm that is going to suck up all your data, come to weird conclusions, and therefore we need transparency, rectification, we need all these things. And now exactly at the time where this is the reality, then suddenly the argument is we have to get rid of all these rules that were meant for exactly that situation. So that always icks me a bit on all of that. If you actually read it, you sometimes feel like the commission had this idea of we want to get somehow to the AI promised land. And to get there, we just got to cut right through the whole GDPR. So it sometimes feels like, just going through it all. And what do we know from the people, so to say, from who is actually interested in all of that? What's the public opinion on this?
The public opinion is that people don't want AI to train with their data, their personal data. So 7% actually of the people only want that, and the vast majority do not want that whatsoever.
So we had that questionnaire in Germany for 1,000 people or so, where we asked them, do you want your data to go into AI or not? And
exactly. So we had this questionnaire with a set of the public that is analog to the
general
public, and most of them do not.
Okay, so basically there's not much of a democratic backing for saying let's just dump everything into AI.
Right. So that is not in the reasonable expectation of the data subject whatsoever.
So on the changes itself now on these articles, we have a couple of changes that interact with each other, which is a bit weird. Can you explain how that goes together?
Exactly. So we have, first of all, Article 6.1f of the GDPR, which remains, the wording remains the same, but it indirectly changes because we have another article, 88C, which we'll see later. So we have a lex specialis for AI training and operation put into as an additional legal basis as a free pass for AI.
Okay.
Then we also have an opening clause, Article 9.2K, a new allowance for AI training with sensitive personal data, and then some conditions, additional conditions for its application in paragraph 5 of Article 9.
Okay. So basically, on the sensitive data, we jumped this for now because that's another layer that probably would go over time.
Yeah.
But generally, you can now have 9.2 where you can go through. Then you have to do the 6F analysis anyways, even if you have sensitive data. And the 9.5 says roughly what?
The 9.5 says that when you have remaining personal data, you generally have to remove it, but only if it's operationally possible for the controller.
So it's basically clean up the sensitive data as far as you can.
As far as you can, and only with undue delay, and as much as it's effectively possible.
Okay.
And
so
this is not
conditions.
a lot of conditions, not clearly explained, neither in the recital nor in the actual article. So how this is going to apply, we don't know.
So another reason for good clarification where in the future this omnibus clarifies all the questions we ask, and in reality opens up 100 new questions. Okay, let's look out into the personal data. So typically in legitimate interest, we have the 3-prong test, and we now still have that.
We still have that, but a bit different. So we need to have a legitimate interest right now when development and operation of AI is involved. So this is a standalone legitimate interest in itself, when in fact we have had the Court of Justice of the European Union say that commercial interest in itself cannot be legitimate, just scrape the entire into.
So that's the Google Spain argument.
That's the Google Spain argument right there. And this goes directly against that.
Okay.
And then we have the AI term, which is quite broad as a definition. It's defined as in the AI Act.
Which we're going to get to in 1 second.
Yes.
And
then we have two different conditions, a maybe wording and a where appropriate. So this legitimate interest may exist, but only when the controller says that it's appropriate to do so. But who will judge that? The courts, the DPAs, and how they will interpret that? We have no idea.
Kind of like direct marketing may be a legitimate interest, which we have in the recital under, was it 47, I think? And we still debate 10 years later when the maybe actually is true and what does. Okay, so same idea there. And
all of that, unless there is a consent requirement in union or member state law. So that could lead to fragmentation and uneven standards of protection.
So there is now an opening clause that you could basically say there is no legitimate interest if, let's say, Greece says we want to have consent for AI training. And then you have to filter out the Greek data.
You have to filter out the Greek data from the data of every other European country.
We don't have the geographic definition of is it Greek citizens, residents, data stemming from there.
And also operationally, how is that going to happen for controllers? We don't know.
And
so this
different consent ages then too.
Exactly.
Because if it's consent, then each country has its own rules.
How is that going to apply in the digital single market that the EU Commission envisions?
So not really clarification or simplification here. Okay, interesting. Next up, basically, we then have the question of these definitions to kind of go into that. So artificial intelligence, what do we understand here as artificial intelligence?
So here, the Commission proposes to follow the definition of the AI Act. This definition is exceptionally broad. So we start with a machine-based system that has a level of autonomy and can adapt to its operation according to the objectives, and then can infer different outputs and make decisions. This is a very, very broad term.
I mean,
it could include credit scoring, for example.
Yeah, so a lot of the stuff that we right now would just consider normal data processing, which is not AI as people generally understand the AI to be, could be included in the AI definition because it's so broad.
Exactly, so it's so broad. And what's the problem from a data protection perspective is that the legal bases are basically an opening clause to process personal data.
Yeah.
When the opening clause becomes too broad, the controller can just use it and expand it for whatever processing operation they imagine with AI. So they will justify operations just because it's AI and will make it a legitimate.
So it's kind of interesting because for the AI Act, we wanted to have this broad definition to protect more people. And now if that definition is used to legitimize data processing, exactly the opposite situation happens, that a lot of people lose their rights once you're able to claim it's AI. At least they lose their legitimate interest level of the test. Okay, interesting. And then what's also kind of icked me a bit is definition that there is development and operation of AI systems. Like we always talked about AI training, we hardly talked about operation of an AI system before in discussion.
Exactly, and even the EDPB, in its opinion, kind of explain different steps of the processing with AI systems. This is not reflected at all in the proposal of the Commission, which just have development, which we assume is training, and operation, which is everything else.
So we basically put on the slides, it's like operation is probably what they mean is processing, as we would usually call it in the GDPR. And that would be basically a general AI privilege. So once you process data with an AI system,
Exactly.
you have more rights to do so than with a normal dumb old database.
It's a free pass for AI, essentially.
Yeah.
This new provision.
Yeah, I mean, for the legitimate interest step, we're gonna move on to the next steps in a second. But I think what's interesting is that for the first time, it's also not technologically neutral anymore. We used to have tech neutral laws. Now, for the first time, we put one type of processing into the law as being privileged somehow, like as if we would have put blockchain into like a privilege in the GDPR or something.
Exactly.
Yeah,
And that could also create issues from an equality before the law perspective.
Yeah. Let's move on the rest of the test, because basically we still have the necessity test. That's exactly as before. And then the balancing is kind of deviated or not from 6.1f.
So this is kind of weird. Stay with me. The balancing is copied one-to-one from Article 6.1f, but at the same time we have different elements that are referred to that are not exactly the same. So we
Still have
to do 6.1f with the balancing of the interest of the controller and against the rights and freedoms of the data subject and pay attention to children. But at the same time, we have some organizational and technical safeguards, but they still remind us of data minimization, which is explicitly mentioned, or Article 5.1c. We have protection against non-disclosure, so confidentiality and other security measures of Article 32, and enhanced transparency obligations, so 5.1a and 13 to 15.
more than 13 to 15 because it has to be enhanced somehow.
That is
Okay.
not explained in the recitals either, so we don't know what they wanted there.
Yeah.
And of course, an unconditional opt-out, which refers to Article 21.2 for direct marketing. This could be what they envision, but we'll see how this could apply or not.
Okay. If we talk about the unconditional opt-out, that was something I was getting worked up about as well. If we go through it in basic practice, I mean, the controller has to somehow identify the data subject, but we have messy training data. So how do you do that?
Basically, you can't, because also you have an opposition with Article 11 where the controller has already identified the data subject. They're basically allowed to kind of delete the data. So what do they do there when they have to inform the data subject according to Article 13 and 14?
So you don't have to, under 11, you don't have to identify someone only for the purposes to comply with the law.
Exactly.
Therefore, you probably will never inform anybody if you have unstructured data.
And they don't even have the contact details whatsoever with unstructured or
I mean, to be fair, someone like Meta taking the data of all their users would have the contact details and would be able to do that, but most others that just straight from the internet, not really.
Third parties won't.
Now, the data subject would basically hardly get information about that, because, I mean, if they would, for whatever reason, find out that happens, they could basically then do kind of random opt-outs and just send to any company saying, I reject. And then, I mean, I even thought you can have an opt-out bot to just like spam all the companies in Europe to say, don't use my data for AI training. But, I mean, that's the options that from a data subject's perspective.
Or even a Robinson list, so a list of data subjects that don't want to have...
but that's not in the law.
No, it's not in the law.
But it could have been a logical way to at least avoid 100,000 opt-outs flying.
There, so we don't know how this will be operationalized.
And then last but not least, if you have this opt-out situation, I mean, what's kind of interesting that we had in other cases that we pursued on AI was this question of how does the data subject, the controller even identify the data subject? Because now Cleanti and Max come around and say we want to opt out, and they would have to even be able to find that data in the data set.
Exactly. There's no clue on how they could do that. And also the problem is that Article 21 is an after-event right. So after the first communication, when you have direct marketing, you can object. But when you have an AI system and the data is already ingested in it, you can't have the option to stop the processing activity.
Now by law you have it. So if you now realize OpenAI does something weird to your data, you opt out and OpenAI has to delete everything?
We don't know because
But that would be what the law says. No?
yes, that would be what the law says, but how will it technically apply? We don't have a technical solution right now.
What the consequence would be.
Yes.
And what I also found interesting is that, I mean, in reality, we also have more than just the 6.1f discussion for AI training. We have this question about accuracy of the data minimization, purpose limitation, data subject rights. And usually in our arguments, we say if you can't comply with any of these other parts of the GDPR, then back in the balancing test under 6.1f, that has to be a negative, because if I know I'm going to process where I cannot, for example, rectify the data, or I may have a lot of hallucinations and inaccurate data, that probably isn't then a legitimate interest, or the balancing test at least goes against the controller.
Exactly. And then you end up doing the same exercise again and again, and you end up with the same results. So when here the Commission wants to allow AI training, we might still have the same exact problem that we started with.
Okay. So interestingly, to go to our last bit that we have in all sections, charter. Does that work with the charter?
How could it work when Article 8 says you have a right to rectification,
Yeah.
you don't have accuracy, and also the fundamental rights and freedoms are really impaired?
But it could, at least from a technical level, I assume, work in that sense that the processing itself is still going through the balancing test. So basically, these arguments could be taken on board in the balancing test, and then the answer is just you can use the AI.
You can use the AI with no technical solutions to all the data subject rights.
Yes. So also not overly satisfying. Thanks a lot for looking at this part. So next up is the changes to the right to access. Lisa looked into that a bit more the last weeks as well, and I probably just going to start off with the history of that, because we saw that a lot, these ideas of changing 13 and 12 and 15. And usually that came out of these German lobby papers where the Germans basically said we don't want that. And for probably the non-Germans that listen to this, there was a big push in Germany that especially employees ask at employers to get a copy of their data, because more and more data, like for example, timesheets of how much hours you worked, are not a paper you can take with you and then litigate, but they're in some system and you may get locked out once you quit a job.
Yeah.
And you can't even get access to it anymore. And the Germans then put out this lobby paper to say, or like a demand by the German government to say we want to have that in law. Where did it end up now?
Well, that ended up in the law. And so now we are in a situation where basically we have a sort of purpose limitation for the data subject right to access. So people can access their data if they have a data protection purpose, which is a huge restriction of the right, because normally the right to access can be used for any purpose.
Yeah.
And it's also an enabler of other rights under the GDPR, like restriction, like rectification or deletion.
And I mean, if it's data protection purposes, how about someone saying, I want to have access to my credit ranking data because my loan is so high, because my credit score is so bad, and actually I think it's wrong. That could already be something where a company could say you're not accessing purely for data protection purposes, but economic interests in reality, or...
They could try to say, you have an economic interest here. It's not purely data protection, so it wouldn't work.
And then you can appeal that up and down for 10 years to finally get your data, because, I mean, I would assume such arguments may not even fly in practice, but it's another argument that companies can use to deny rights in reality.
Exactly.
Now, we also looked at this Court of Justice rulings that idea. What's up with that?
Well, the Court of Justice consistently consider that the right to access can be used for any purpose. It doesn't depend on the context in which the right is used. And for example, in FT, it was a person that was asking for access to their dentist because they suspected that the dentist made a medical error. And in the end, the Court of Justice said, yeah, sure, you can have access to your medical file. And in the new case with the amendment, it wouldn't be possible, likely, because they would have a medical purpose.
Yeah. So it's interesting because usually I always understood the right to access to also be like part of this right to informational self-determination, that you can get access to the data that others hold about you for whatever reason, not just, I mean, it's an enabler for other rights, but it is not purely meant to only be an annex right, so to say.
Exactly. It's a right as such.
Yeah.
And it's also part of the Charter of Fundamental Rights.
And exactly that is the point I wanted to get to as well, is we had this question because, I mean, the Court of Justice rules that, but the legislator can change it and just say, we don't agree with the Court of Justice, and we'll just say now this is more limited.
Well, the legislator can limit a right under the Charter only if it's necessary and if it's limited to the principle of proportionality. And here, I assume they go way further than
Yes. So basically what we would need is the Court of Justice to say under Article 15, there was no purpose limitation, but under the Charter there is purpose limitation, and therefore it's still compliant with the Charter to do so, which I would assume is a bit unlikely that the Court of Justice would do that.
Stretch, I would say.
So again, that's one of these cases, if we think about it, where probably we'll have a certain tension with the Court of Justice accepting a change like that.
certainly the Court of Justice would, I suppose, continue with its consistent case law to follow the Charter.
Yeah, and basically just say, we told you 3 times that there is no purpose limitation. Under Article 15, there's no reason why under Article 8.2 of the Charter, where the right to access is in the Charter, there is a different rationale. So if the legislator just does that, probably it's not legal in high likeliness, I would say.
High likeliness that the Court of Justice doesn't go against the Charter.
And just overturns that. Okay, another wonderful one that gives us more legal certainty and clarity with this law, which is the original intention, apparently. For the next bit, I'm actually alone without a colleague, because the colleague that worked on that isn't at the office today. But basically changes to Article 13. So this idea of a SME exemption for privacy policies. The recital says that the idea was like the basically plumber that goes to your place fixing something, having to kind of give you a privacy policy otherwise. Now, there is probably some sense to all of that. The question is if the way that this was written helps anybody. If we go through the definition, there must be no in-depth processing. So, for example, we're a small NGO. We wondered, we have 30,000 email addresses from newsletters. Is that in-depth processing or not? Can I then say for this part I don't have a privacy policy and for other I do? That's all pretty unclear. They also say that there has to be a clear and circumscribed relationship. We had very hard time to think about what is not a clear relationship, like what are unclear relationships in general. I mean, whatever you think about it. There also has to be reasonable grounds to assume that the data subject already has that information. In many privacy cases, people probably have no clue what's going on and probably also don't care too much. So it's a bit of a question of how that should really be assessed. But, there may be situations where you have that factor. The big problem I see is that there are exemptions to that. So once you have a recipient, which includes just any processor that you may use, this exemption doesn't apply to you anymore. So we have an exemption from the exemption that swallows the rule in 90% of the cases. Simple terms, most plumbers do not run their own email server. And once they don't do that anymore, they cannot avail of that exemption. So it's kind of like an exemption for PR purposes only that probably in reality almost no one is going to be able to use. Also, if you transfer data to another country, which is as soon as you use some cloud provider, you probably do that. That again is something that is outside of the definition, and you then leave basically that exemption. Automated decision, high risk. Again, high risk as many cases in the GDPR are not properly defined. So if you do high risk, then suddenly you have to go back into that. There is a bit of a problem with the Charter as well, because the transparency principle is not explicitly in the Charter, but there is the problem that you have to be fair when you process data. And the question is, if you don't provide that information, is it still fair? What happens, for example, if people say, you didn't give me the privacy policy, I want to orally now ask you about these questions, or I requested via email. Can you then just say, I'm still doing fair processing by not giving you that information that is usually provided in Article 13 or 14? Quite questionable. The big problem is really these exemptions, so to say. So there's a lot of legal uncertainty. It's really anything but a clarification. So you have these situations where you get out of the law, back into the law. So it's quite interesting how some of this would go together in practice. What is in-depth processing, for example? And the big issue is if you do not comply with Article 13 for the wrong reason, so data protection authority decides. After all, NOYB does do in-depth processing because, I don't know, the number is so high of the data subjects that we have, then suddenly we would be liable for an up to 20 million euro fine under the GDPR. So it's quite interesting to have these very wacky definitions combined with, as always in the GDPR, these extremely high fines. Usually we say in law, the higher the fine, the higher the consequence, the more proper the definition has to be. In this one, not so much. The reality for SMEs is that the counter exemptions basically swallow the situation. I would say probably 99% of SMEs do not process the data on-prem and therefore would fall outside of that definition. Also a big problem from a data subject perspective, there's no information about the legal basis, for example, anymore. Like most of the other information under Article 13, you could get through an access request, but there's certain stuff that is not covered by Article 15 because we assumed that everybody got that under 13 already, which is, for example, the legal basis for processing. So if you want to know if you can actually withdraw, you don't know if it's actually based on consent. If you want to object, you don't know if the processing was based on the legitimate interest and what the objection is now. So it's quite interesting how this would go together in practice because some other articles of the GDPR require to a certain extent that you got that information up front. Also, there could be possibility that there's just more access requests. So if I want to have that stuff answered and I don't get it through Article 13 proactively, I would then basically have to make an access request to get that information. Charter compliance, already mentioned, that could be a bit of an issue because of the fairness principle. Or, for example, if you have consent has to be informed. If you didn't get that information anywhere, that could potentially be a problem around these transparency rules. So that's interesting. I think the bigger picture is it's kind of like they wanted a PR story to say there is some way that you can actually help SMEs here. But I think most SMEs in reality, if they read through this definition, are going to get a heart attack and be like, I don't know if I'm in or out and what I'm doing here. And then suddenly it could be that a lot of the SMEs would suddenly not find that all too helpful. Again, it's one of these things where the promise of the Omnibus was to clarify and to simplify, and in reality, it's probably more complex than ever before. So if we would have had a definition saying if you have less than, 500 data subjects, you don't have to do it, that would be measurable. That would be something we could actually measure and say yes or no. But in this situation, it would be a bit interesting how that plays out in practice, especially if you have a DPA that, for example, wants to go after, like us, a nonprofit organization that may be politically not wanted that much. That could be an easy way to say, oh, you misinterpreted in depth and now you come around with a big penalty. That is stuff that from a certainty in law perspective is definitely a problem. So, Lisa, we also talk about the question of what all happens to the so-called cookie banner law.
Yeah.
So Article 88A, B, and Article 5.3 of the ePrivacy. What happened there, actually?
Well, what happened is that we have a new Article 88A that will tell us what to do with the storing and access to personal data on a device. So a sort of lex specialis to the GDPR. And in there, we have some new legal basis.
Let's wait with the storage and access to device. That I think a lot of people still think that's the cookie law, so to say, but it goes much broader. It basically is any pictures on your device, any kind of like file on your device, anything that a software could pull out of your device and get out of and use it for something. Yeah. So it's not just a cookie law, so to say, but a much broader breadth of what can be pushed out of and into a device.
Yeah, indeed. We should not reduce it to cookies. But so now there are new legal bases for which controllers can store or access personal data on the devices. And like the general rule would be consent, but then we have carrying out or transmitting electronic communication that was already in the ePrivacy. We have providing a service that was also already in ePrivacy. And the new ones are creating aggregated information for an audience measuring. These terms are quite confusing and they are not defined under the GDPR. For aggregated information, it's also confusing because it could happen to on several weeks or months. And so
some people could argue, oh, I aggregated in 2 years, so I'm now fine.
So I'm now fine and I can use the exemption or not. And the last exemption would be the security, so maintaining the security. And this could also be interpreted broadly by controllers because a lot of actions that they could perform on a terminal could be linked to security.
So we had a case, for example, a bit like about online games that basically search your whole computer to make sure you're not cheating. And that could be something where they could say it's a security purpose, so to say, and we just go through all your stuff on your phone or on your computer.
Yeah.
So what's interesting, I mean, so far that was 6.1f, I would say. And there we would have a balancing test, and that's not here.
A balancing test, and here there is no balancing test.
So once it's necessary, we're done.
Yeah.
Yeah. Okay. That could also be a bit of a problem. What then came up a lot as a discussion is this reference to Article 6. So some people understood that to be a reference to all legal bases in Article 6.1.
And I understand the confusion, but the recital, I don't have the number here, but the recital enlightens us and tells us that this relates to Article 6.3. And this refers to Article 23 of the current text of the GDPR. So it would be in cases where a legislation is needed to secure a democratic society and to safeguard the defense and things like that.
But that could, to a certain extent, allow to have a national government in Europe have a law to say, I thereby can ask Google or Apple or Microsoft that has access to a lot of devices to kind of provide the information from these devices by our national law that we have.
That could be, and that is not the case under the current text, but it could be under this amendment.
Yeah, so that could be the understanding of what's up here. Then basically, there are a couple of limitations on consent, which is interesting. I mean, that's this whole idea of dark patterns, and can we do something around that? What's in it for that?
Yeah, Article 88A, paragraph 4 is relating to design, and it says that there should be a single click button or equivalent means to refuse consent. First, equivalent means, it's a bit unclear what that would entail, and then a single click button, it's actually what we had already in the guidelines
of the data protection authorities, since there are fairness and so on, like usually,
and of the EDPB,
yeah.
And so that doesn't change actually, but it doesn't also prevent that other deceptive designs are used by controllers.
Because I mean, single click, it can also still be a gray button, a little link, like that's not clarified how that single click has to look like. No. Okay, and that's in reality. I mean, there's usually a single click, but it's so hidden that no one finds it.
Yeah, exactly.
So it's a bit of a half solution. And then there's the 6-month period for repeated requests. How should that work?
Well, sorry, I need to take the text. So that would be the controllers that have to track if you said yes or no to their trackers. And this amendment is not so useful because it actually pushes the controllers to track you even more.
Yeah, so basically you then have to store the refusal and somehow link that person has refused before and link that to a person.
Yeah, so you would need a sort of identifier one way or another.
Okay, interesting. That's interesting how that in practice is going to work. Like, for example, I clean all my cookies when I close my browser, and then how are they going to know I refused or... Okay. Then one thing that I can talk a little bit more about, because we worked a lot on that, was these privacy signals. So there is now basically this duty of controllers to accept a consent, rejection, or objection, but not a withdrawal for whatever reason, via a digital signal. So that was really debated in the last, I think, one or two decades. So we basically have this discussion for 10 years by now that there should be a signal, so to say, to do that. So that is going to be in, and there is this duty of controllers to also accept that signal. Interestingly, that is different for, that is kind of a bit different for the current law that we have that already under 21.5 had a duty, but only for objections.
Yeah.
So we're basically widening that now to also consent and do rejection. What's really weird, there is a exemption for media companies. So basically, if you're a media company, you don't have to listen to that signal. I thought what's going to be interesting is that then basically only media companies still need a cookie banner, which would give you that warning of, oh, journalism tracks you and other companies not. That could be a bit of a counterintuitive situation, but yeah.
But only when providing a media service.
Yeah, exactly.
Strictly interpreted, maybe tracking wouldn't be covered.
So it could be that de facto media companies just comply with it anyways because they don't want to have a cookie banner on their site, but let's see. There is going to be this European standardization of the signal, but the details are very unclear. So there is thoughts of having a signal that is more like a general yes or no signal where it just have one button in the banner or in your browser, but there could also be signals which we always advocated for that have, yes or no, dependent on the purpose of the tracking, dependent of the controller, so that there's more dimension. That's currently not in the text, so it's going to be interesting because if that's all left to technical standardizations, then all this legal debate of how do we want to have a signal like that would happen in the standardization body, which is a bit weird of how that would go down. Next, basically, we then have a duty by web browsers to actually implement that as well on the other side. So that could be quite interesting because these web browsers then have to allow these signals actually in reality. And finally, there's not a duty for other terminal equipment. So if you use, for example, a phone and an app there that also tracks you, then there's no duty to allow a one-button solution or a digital management of in
The
there.
operating system.
Yeah, because a lot of the apps basically have a cookie banner by now in the app, so these cookie banners would not be covered necessarily. What's also interesting, what I found just amazing, is there's an exemption for SME web browser providers. So if you're a web browser manufacturer that has less than 250 employees, then you don't have to build that into your system, which I was wondering if that exists. But on a political message, that could be quite interesting because if we get rid of the cookie banner, a lot of that hate in the European public against the GDPR that I think mainly stems from the cookie banner could actually go away. So that would be quite interesting. And the last bit on all of this, we also have changes to Article 5.3, where originally the cookie law, the access to the terminal equipment was regulated. How does that now work?
Well, now Article 5.3 is limited to data that is not personal, because now the regulation for personal data is in Article 88A that we talked about a bit before. So now Article 5.3 has a few legal bases. The general rule is still consent, but what is interesting is the interplay with Article 88A, which has more legal basis for controllers to store or access data on the device, while Article 5.3 has less.
So we have a reality now that personal data is less protected than non-personal data in this provision.
Theoretically, it would be like that.
That would be interesting. I had a lawyer that I talked to that said, we always argued nothing is personal data. Now we have to argue it is personal data to have more possibilities to process it.
Yeah.
That's quite interesting. The last bit, just to mention on this, there is also the idea, there used to be the idea of black and white, either it's personal data or it's not personal data, and then you fall under GDPR or ePrivacy. They can now change the wording and add it or leads to the processing, and that could be interesting because you would have a gap in between where it only leads to the processing, so you fall outside of ePrivacy, but it's not processing yet, so you're not in GDPR yet.
Yeah.
And then you have a little bit of a gap in between. One last thing that probably would be interesting to highlight as well is that a lot of this is actually based on Article 7 traditionally of the GDPR, of the Charter of Fundamental Rights, so the right to privacy and communication. And it's quite interesting that now a lot of that could be a bit watered down and how much that all complies with the Charter. I mean, I think about this, for example, access for security purposes without a balancing act, if that is proportionate necessarily.
Well, I doubt that GU would.
So probably have to add a proportionality test here or something, or
It would make sense that it comes at least out of the case law.
Yeah, so that will be interesting how that in reality works. Now, a final summary of all of what we've heard. How can we characterize at least these elements of the Omnibus that we went through? I think my takeaway personally would be that this whole simplification and helping European SMEs was a mere talking point. Like basically that is what politicians wanted to hear and wanted to put out there, but the law that we see doesn't really have that in it largely. There is here and there a bit of a sprinkle of useful clarification. For example, if we think about the data protection impact assessment and having black and white lists, which is something that can generate more legal certainty, but that is not kind of the breadth of the law. It's exceptions where we do have that. There is largely more of a deregulation that make it just especially the enforcement of the GDPR very hard because you have these undefined legal terms and then it's going to be really hard to make sure that this is properly enforced because, any court may have a different interpretation. Also quite interesting because they always refer to the Draghi report that highlighted that we need more consistent law, clearer law. I don't see that here really. there are a lot of changes that may actually get into conflict with the charter. A lot of the stuff where the Court of Justice said it one way and can probably rely on the charter to say it that way. And now basically politicians, especially the commission, tries to get it another way. And it could well be that the Court of Justice then says, guys, I told you, for example, Article 15 is open to anybody for any purpose. I now just tell you that again under the charter and not just under Article 15. And then 5 years later, we just get back to square one. And that probably doesn't help anybody in this game. The next thing that we see is that the commission and the drafting still has massive quality issues. There's definitely better quality than the original leaked version that was mind-blowing. But a lot of the text drafting, you see that people have drafted that probably don't know how the GDPR works. Like if you say that once you have a recipient, you still have to do a privacy policy, you must know that basically any SME has a recipient. So it's quite interesting that these things are not something that the drafters said, that wording doesn't make any sense here. What's interesting is overall, I feel that a lot of that is really driven by PR, by the need to go out and signal to the market that we are somehow getting rid of regulation, not really by proper resolutions. A good example is the AI rules, where you can say, okay, there is now this rule, but do we really now know anything more about when we can use AI or not? We still have to do the balancing act. We still have to do these things. The fact that training may be a legitimate interest is nothing that anybody really questions all too much. The real problem is, how do we do the balancing act? So a lot of these things are exactly the things where we wanted to have clarifications, but we didn't really get them. Now, what are the next steps? We are, as I said at the beginning, at this point where we basically now had the final version, and we're now going to see moving forward how everybody else reacts to that. Now, we did all of that a bit of in a rush and tried to kind of get it out quickly, being aware that there may be other problems that we're not aware of, or that something is a bit different. So it would be really interesting if you have any feedback to let us know. You can just email us at info@NOYB.eu. And last but not least, we now will have to work a lot on this. And I also realized a lot of people actually enjoy the content we're producing a lot. So if you want to support what we're doing, you can also become a member and support this work. And just go to our website and find out more about that. Thanks a lot. Thanks for taking the time. And I hope that we'll kind of dig into this omnibus deeper and deeper and find out what does work and what maybe was not the best idea. And which maybe, in my personal view, we could probably look at in the digital fitness checks that the European Commission wants to do the next years, and actually think about proper solutions that are not drafted overnight on a weekend and probably don't help anybody. But we'll see where all of that goes, and then what the political process is going to do in the end. Thanks a lot. See you then.